Welcome to our webinar, The Volunteering Relationship, Distinguishing Between Volunteers and Other Workers in Community Organisations. My name is Nadine Claude and I'm joined by my colleague Amy Williams to present today's session, which will run for about 45 minutes or so. We are both lawyers in Justice Connect's not-for-profit law service, which I'll introduce in a moment. This webinar is being recorded in Melbourne, so we would like to respectfully acknowledge the traditional custodians of the land on which we are recording from, the Kulin Nations, and pay our respects to their elders, both past and present. We would also like to acknowledge the traditional custodians from all parts of the country you are listening from. Before we begin, we want to make clear why this is an important topic and why it is important that you listen in if you are a volunteer involving organisation, or if you are thinking about involving volunteers in your organisation. The law recognises many different categories of workers, paid and unpaid, such as employees, independent contractors, and volunteers. This webinar will help you to understand the key differences between the different categories of workers that your organisation might engage, and in particular, highlight why it is so important to understand these differences and provide you with some practical tips for clarifying the status of your workers. One final note, our focus as lawyers is to talk about how the law defines categories of workers. It is important to acknowledge that this is just one part of the picture when working with volunteers. Volunteering peaks, such as Volunteering Australia and the state-based volunteering peaks, play a crucial role in the volunteering space and provide a range of extremely useful resources for volunteers and volunteer-involving organisations, including best practices, to help compile the rest of the volunteering picture. Let's get started. For those of you who do not know much about Justice Connect or who are using our service for the first time, Justice Connect is a community legal centre with a range of services that you can see here on the screen. The not-for-profit law service is circled in red. Justice Connect is a not-for-profit organisation and we are a registered charity. Like your organisations, we also engage volunteers, employees, and at times other types of workers. At Not-for-Profit Law, we offer a number of services to not-for-profit organisations. To access this freely available webinar, you would have come through our not-for-profit law website, specifically the people involved tile on the screen. The webinar is one of hundreds of freely available resources on our website. On the screen, you will see other tiles with topics such as running the organisation or important agreements. Behind each tile are fact sheets, guides, template checklists, and videos providing legal information on a variety of topics relevant to not-for-profit organisations. On the topic of volunteers, you might also be interested in our new National Volunteer Guide and our other free webinars called The Volunteering Relationship and Unpaid Workers. In addition to resources, we also provide training. We run low-cost webinars, which are different to this freely available webinar and include a live Q&A session in which you can ask questions and get some answers. And we also run customised in-house training for not-for-profits, local councils and peak bodies that want to engage us for something more targeted. We also have a free telephone advice service for eligible not-for-profits who haven't been able to find the answers to their questions elsewhere. Throughout this webinar, we will mention that you might need further legal advice on a specific topic. If your organisation meets our eligibility criteria, we might be able to assist your organisation on a pro bono basis. Click this tab on our webpage for more information. And finally, we do a lot of law advocacy work to cut red tape across the not-for-profit sector. So, what are we going to cover today? We're going to cover 5 different things. Firstly, why it is important to distinguish a volunteer from other types of workers. As not-for-profit organisations, we engage with a variety of people and a variety of different types of workers. Throughout this webinar, we will refer to workers to describe people who undertake work for an organisation, whether paid or unpaid. We're going to talk about what is a volunteer. That is, how do we define this category of worker at law? We're going to talk about the differences between a volunteer, employee and independent contractor. The question of whether a person is an employee, independent contractor or volunteer under law depends on the entire relationship between that person and the organisation, rather than the name that you might give that relationship. There are times when the way you engage a volunteer may actually give rise to an employment relationship even though you had intended to engage and label the relationship as a volunteer relationship. This can be a costly mistake to make. We're then going to take you through some steps that you can take to make sure you are engaging a worker as a volunteer and not as an employee or an independent contractor. And finally, we're going to talk through some frequently asked questions from our volunteer involving client organisations. And now I'm going to pass over to Amy.
Thanks, Nadine. Let's launch into our first topic, why it is important to distinguish volunteers from other types of workers. Today we are going to use this real-life case, Grindholes and Football Federation Victoria, to demonstrate the importance of distinguishing volunteers from other types of workers. It was a matter that was heard by the Fair Work Commission in 2016. As you can see from the screen in his judgment, Commissioner Rowe stated, Mr. Grindholes argues that he was an employee, whilst the Football Federation argues that he was a volunteer. Then later on in his judgment, there is no evidence that Mr. Grindholes was ever described as an employee or told that he was an employee. Then further on in the judgment, the indicia, that is, the signs that he is an employee or volunteer, in this case point both ways and do not yield a clear result. Let's take a closer look at the background and some of the indicia in this case. Mr. Grindholes was the head coach of a girls' soccer team for Football Federation Victoria in the 2015 and 2016 seasons. He signed a voluntary services agreement with the football club that said he was not entitled to any fee or payment for services, and the services would be provided on a voluntary basis. He was paid $4,000 in 2015 and $6,000 in 2016 to assist with travel, accommodation, and out-of-pocket expenses. He was required to satisfy performance criteria, otherwise risking breach of contract, and some of these criteria included attending 100% of the squad games and training sessions, acting consistently with policies, promoting the organisation and wearing the uniform, and achieving 85% satisfaction or higher level expressed by players in the post-season survey. In October 2016, the football club ended Mr. Grindholes' coaching role on the grounds that he had forfeited a football game without appropriate approval. Mr. Grindholes made an unfair dismissal application to the Fair Work Commission. The football club objected to the application, arguing that Mr. Grindholes was a volunteer, not an employee, and therefore was not entitled to an unfair dismissal remedy under the Fair Work Act. Maybe you can see why Commissioner Rowe stated the indicia in this case point both ways and do not yield a clear result. So what do you think? Was Mr. Grindholes an employee or a volunteer? Ultimately, despite the indicia pointing both ways, the Commissioner found that in this case, the balance was towards a volunteer, not an employee-employer relationship. It was the mutual intention of the parties to clearly establish a volunteer relationship and not an employee relationship. We will touch base on why Commissioner Rowe decided Mr. Grindholes was a volunteer and not an employee later on in this webinar. But for now, I want to highlight the importance of clearly distinguishing volunteers from other types of workers, such as employees. First, if the Commissioner had thought that Mr. Grindholes was an employee, the football club could have been found to unfairly dismiss Mr. Grindholes and they may have been liable for unpaid wages, superannuation, and annual leave. This would be a costly expense that could have been avoided if the football club had been clearer on the nature of the working relationship from the outset. Second, it provides really important clarity to the worker. Mr. Grindholes believed himself to be an employee. If, say for example, he had injured himself and tried to claim workers' compensation, he may not be covered by insurance as a volunteer and may be left exposed to cover the cost of his own injury. This is not a position that we want to expose our volunteers to. In summary, this case demonstrates why it is important that your organisation understands what kind of worker everyone involved with you is, as this affects their rights and your obligations. Let's take a look at the different rights and obligations for different categories of workers. This table on your screen is a summary of the different legal entitlements of volunteers, employees, and independent contractors. For example, Volunteers are not entitled to be paid for the work they perform, whereas employees and independent contractors are. As you move through the table, it will become more and more apparent why incorrectly categorising a worker can be a costly mistake. There have been a number of cases where the court has had to consider whether a person is an employee or volunteer, as that person has claimed unpaid wages or unfair dismissal, just like we heard in the case of Mr. Greenhalgh's. These entitlements are only owed to employees and not volunteers. There is more information about the legal entitlements of these different categories of workers in Part 2 of our National Volunteering Guide. In addition to the varying legal entitlements for different categories of workers, there are a number of issues that turn on whether the person is a volunteer as opposed to another category of worker. Firstly, insurance. Whether or not someone is covered by your organisation's insurance may depend on their status. That is, insurance policies differ between volunteers, employees, and independent contractors. Work health and safety laws. This is a complicated topic that we do not have time to cover, but the application of work health and safety laws may differ depending whether or not your organisation only engages volunteers, and certain provisions of these laws will only apply to paid workers. Vicarious liability for the actions of a worker. Your organisation can be legally responsible for the actions of particular workers, so you need to know who they are and what they are doing. The application of equal opportunity laws that cover discrimination, sexual harassment, victimisation, and bullying can vary depending on how a worker is engaged. Legal status in Australia. If someone is holding a visa with work restrictions, they may be able to volunteer under the conditions of their visa, but if you accidentally treated them as an employee, they may be breaching the terms of their visa. Eligibility for government payments might change depending on your worker status. All of the above again illustrates why it is important for both the organisation and the individual worker to be clear about the status. More information about all of these topics can be found on the volunteering page of our not-for-profit law website, including in our National Volunteering Guide. I'll pass over to Nadine.
Thanks, Amy. So now we're going to talk about defining a volunteer. On the screen is a quote from a case that dealt with the question of whether or not someone was an independent contractor or an employee. It says, the infinite variety of human affairs means that work relationships present as a spectrum, some of which are clearly relationships of employment and others of which are clearly relationships of independent contract, and some of which are clearly volunteer relationships, but some of which are less clear-cut. Just to note there, we have added in the reference to some of which are clearly volunteer relationships. We like this quote for two reasons. It describes the nature of engaging people to do work for an organisation, that sometimes it is really clear what categories people belong to, but at other times it is more fuzzy or closer to the edge of one category, possibly falling into another. We will touch base on that a bit more today. We also like this quote because it refers to a spectrum. In the not-for-profit sector, it is often a simple dichotomy. Is this person an employee or an independent contractor? But in the not-for-profit sector, it looks more like this. As you can see from this slide, there are a myriad of working relationships that exist in the not-for-profit world. In this webinar, we are focusing on volunteering relationships, which you can see on the left-hand side of the screen. More specifically, we'll be focusing on the traditional volunteer relationship in green, and employment relationships in red, and contractor relationships in purple, which you can see on the right-hand side of the screen. We also have a freely available webinar that covers off on the orange section of the spectrum. That is work under a court order, work activity for government payment, such as work for the dole, and vocational placements or internships and work experience. This webinar is called Unpaid Workers and is available on the same page of our not-for-profit law website as this webinar. What is important to recognise from this slide is that volunteers are a special type of working relationship that is different to all the other types of working relationships. So we know that volunteers are different to the other types of working relationships, but how do we define the concept of volunteering? Unfortunately, in Australia, there is no accepted legal definition of a volunteer. We do, however, have some guidance. Volunteering Australia and state and territory volunteering peaks use the long non-legal definition, time willingly given for the common good and without financial gain. Volunteering Australia has also released guidelines around this definition, and further information can be found on its website at www.volunteeringaustralia.org. Even though there is no accepted legal definition, there are some key indicia to help you identify whether or not someone is a volunteer. The Fair Work Ombudsman has identified the following characteristics of a genuine volunteering arrangement based on its own review of case or judge-made law in this area. A volunteer is someone who does work for the main purpose of benefiting someone else. The organisation and the individual did not intend to create a legally binding employment relationship. A volunteer is under no obligation to attend the workplace or perform work, and a volunteer does not expect to be paid for their work. Amy is now going to look at some of these different characteristics of a volunteer, independent contractor, and employee. And this will help you put in place mechanisms to make sure you're engaging someone as a volunteer, if that is your intention.
Thanks, Nadine. Often the parties to a contract or an agreement for the performance of work will try to describe the nature of the relationship between them. For example, a document may state, "This agreement does not create a relationship of employment," or that the parties agree that their relationship is one of principal and independent contractor. While it is a good idea to write down the terms of the relationship in an agreement so that both parties are clear about the arrangement, the label you give your worker will not, by itself, determine the nature of the relationship. The question of whether a person is an employee, an independent contractor, or a volunteer is decided by looking at the entire relationship between the worker and the other party. As the court has said in one case, the parties cannot create something which has every feature of a rooster, but call it a duck and insist that everyone else recognise it as a duck. The way an agreement classifies or labels a worker is just one factor that will be considered. If the matter went to court, the court would look behind the description of a situation in the document to what is actually occurring in practice. Let's take a closer look at some of the attributes of a volunteer, employee, and independent contractor. A worker will normally be found to be a volunteer when the following elements exist. Let's start on the left-hand side of the slide, type of work. The worker works or provides services on an ex gratia basis. This means that they do so voluntarily without a legally enforceable obligation to do so and with no expectation of payment for work performed. Any agreement between the volunteer and the organisation, whether verbal or written, does not contain any evidence that the parties intended to enter into a legally binding contract in relation to the work to be carried out. The volunteer arrangement can end at any time, either by the volunteer or the organisation. Now onto the right-hand side of the table, payments and benefits. Generally, a volunteer has no legally enforceable right to receive payments such as honoraria, allowances, or expenses. Honoraria in this context essentially means an honorary reward for voluntary services. A volunteer may be reimbursed for out-of-pocket expenses. Whilst we say may here, it is often considered best practice to reimburse volunteers for out-of-pocket expenses, and most organisations do so. A volunteer may receive payments like on honoraria, allowances, or non-cash benefits such as free use of facilities or free or reduced price entry to an event. But note that if regularly received and/or of a considerable value, this may add weight to the argument that the volunteer is an employee or independent contractor. More information about these topics can be found in Part 2 and 5 of the National Guide to Volunteering. Now on to employee attributes. A worker will normally be found to be an employee when the following elements exist. So starting on the left-hand side of the screen, type of work, an employee often performs ongoing work under the control, direction, and supervision of the employer. An employee must perform the duties of their position. An employee will often provide their personal services and cannot delegate their work to outsiders, i.e., arrange for their work to be done by someone else who is not another employee. This is because an employment relationship is a contract for service as distinct from a contract of service. It is personal in nature. It is the contract for the supply of the services of the worker personally. An employee often works hours set by the employer, an enterprise agreement, or a modern award. All of these go to control. The absence of control is often indicative of an independent contractor relationship, unless there is a high degree of skill and expertise of the worker involved. Where there is a high level of control and the worker is presented to the world at large as part of the employer's business, or they hold themselves out to the public as being part of the business, then this weighs significantly in favour of the worker being an employee. An employee does not take personal commercial risks and cannot make a profit or loss from the work performed. These characteristics are often associated with a worker that owns and operates a business. Now on to the right-hand side of the screen, payments and benefits. On the right-hand side, we will see all of the indicia of being covered by the National Employment Standards, awards, or enterprise and bargaining agreements. So employees are paid for the time worked. They're often paid regularly, weekly, fortnightly, or monthly, and they have income tax withheld from their salary. They are entitled to have superannuation contributions paid into a nominated superannuation fund by their employer. They are entitled to paid and unpaid leave, for example, sick leave, personal carers leave, annual or recreational leave, or long service leave. They are covered by professional indemnity, public liability, and workers' compensation insurance paid by the employer. And generally, all the tools of the trade are provided by the employer to carry out the work. For example, desks, computers, stationery, unless otherwise agreed. Let's take a look at the attributes of an independent contractor. Unlike employees who are seen to be the subject of control and direction of their employer, independent contractors are often recognised as running their own business and providing services under commercial rather than employment contracts. The ultimate question is whether the worker is acting for another or on their own behalf. Generally, a worker will be found to be an independent contractor when they have control over how to carry out their work and they have the expertise to do so. They provide services to the general public and other businesses. They are contracted to work for a set period of time or to do a set task, and they can decide what hours of work are required to complete that work. They are free to accept or refuse work beyond the requirements of any current contract with the organisation. They are usually free to delegate work to others. For example, they could engage a subcontractor. Onto the right-hand side of the screen, they are paid for results achieved. They pay their own superannuation, income tax, and GST, and they hold their own insurance policies. They may have their own registered business and an ABN. They provide all or most of the necessary materials and equipment to complete the work. For example, they use their own tools, and they are in a position to make a profit or loss from work. These are not an exhaustive list of characteristics of volunteers, employees, and independent contractors. Other factors may be relevant when depending upon the particular circumstances. I'll pass over to Nadine.
Thanks, Amy. Now that we've covered some of the factors that distinguish whether or not someone is a volunteer, employee, or independent contractor, let's spend the next few minutes looking at what you need to do to help make sure the person you are engaging as a volunteer is a volunteer. As we mentioned earlier, documentation will not be the all and end all in determining whether or not someone is a volunteer, but it will certainly help. In the case of Mr. Grinholtz, the Commissioner placed significant weight on the volunteer agreement as evidence of the mutual intention of the parties to enter into a volunteer arrangement. Noting, or do note, that the Commissioner looked at all of the facts, not just the documentation and the volunteering agreement. We generally recommend using a volunteer agreement that actually sets out that the role is a volunteer role and it is not an employment or a contractual role, and that the parties do not intend to enter into legal employment relations in relation to the work carried out. If you do use a volunteering agreement, be clear and consistent in the use of language. Avoid using employment type language. Instead, use volunteer and in reimbursement. We would be pleased if you would do A and B, and instead of pay, salary, or contract, or you must. Those latter terms, pay, salary, contract, or you must, are more familiar with an employment relationship. Part 5 of our National Guide on Volunteers contains an example volunteer agreement and provides a few more tips on what you can put in your own agreement if you wanted to draft one yourself. We also recommend that you induct your volunteers and use a volunteer role description. This will help you be clear about the basis on which your organisation is engaging someone. This isn't so much about we want this to be voluntary work or we want certain people to be independent contractors. What it's really about is the nature of the work and the role. For example, if it is a requirement of the role that you really need the person to be there or you need them to deliver a project by a certain time, then maybe a volunteer who can walk away at any time without any recourse is the wrong fit. Again, Part 5 of the National Guide provides an example of a volunteer position description and more information on inducting volunteers. Also, be really clear on when and why you are reimbursing a volunteer. Be careful that it isn't comparable to a wage or payment for hours worked. And finally, have policies and procedures in place that document all of the above and be sure to keep good records. Right, we're now going to take a look at some of the most commonly asked questions about defining the volunteer relationship. One of the most common questions we get is, can we pay our volunteers to cover their expenses? To put this into some more context and a practical example, we're going to use the following fictional scenario. The organisation, Aussie Teachers in Nigeria Limited, is a registered charity that runs a school in rural Nigeria. They provide education to local children. They rely on volunteers from overseas to teach the children at the school. The organisation relies on these volunteer teachers who commit and dedicate long periods of their time volunteering at the school so that they can help improve the quality of education for children that are disadvantaged, and they do this without an income or wage. Aussie Teachers in Nigeria understands that relocating from Australia to Nigeria and living in a country away for a period of up to 2 years without a wage is challenging for most people. Although Aussie Teachers in Nigeria doesn't pay wages, it wants to alleviate some financial burden on the volunteer teachers by helping cover some living expenses of them whilst they are there. So Aussie Teachers come to not-for-profit law and ask us whether they are allowed to pay their volunteers, and they specifically want to know, can they pay them or can they make a payment to cover the costs of flights, food and rent? However, they're a bit worried that this might mean their teachers will become employees of the organisation. Amy, can you provide some advice on that?
Thank you, Nadine. That's a great question. So I guess if Aussie Teachers wanted to reimburse volunteers for the food, rent and flights, that's completely fine. What they need to make sure is that they need to be careful that it's not comparable to wages. So they might need to make sure that the payment is not calculated with reference to time with the organisation or hours worked, that the allowance does not exceed the expenses actually incurred. And a really good strategy to make sure that that doesn't happen is to reimburse volunteers in accordance with receipts. Aussie Teachers would want to make sure that the payment is not a regular payment, and they would want to make sure that the payment is not a lump sum in exchange for services provided. And I think another really great idea is for Aussie Teachers to develop a reimbursement policy that sits alongside the volunteer agreement to make it clear to the volunteer and the organisation how and when a reimbursement would be made.
Thanks, Amy.
No worries.
Okay. This is another common question that we get asked quite frequently. So let's go back to our scenario. Aussie Teachers in Nigeria now need to attract a new committee member, and they're specifically wanting someone with an accounting background. They think they'd be more likely to attract a committee member if they offer a payment for being on their committee. So again, Aussie Teachers in Nigeria comes to not-for-profit law and asks whether they're allowed to pay committee members for their time as committee members. Amy, can you advise them?
Sure, thanks, Nadine. So generally speaking, the law does not prevent you from paying board members for services. But there are a number of important matters which Aussie Teachers in Nigeria would need to consider before deciding whether or not to pay a board member. So first I'd be saying they need to go away and check their constitution to ensure that the constitution permits payments to board members. They cannot make payments to board members if the constitution does not permit payment. Remember, payment can also not be inconsistent with your not-for-profit clause. That is, you cannot distribute surplus funds to board members. As a registered charity, they should make sure that the payments to board members are in furtherance of the charity's charitable purpose. They should also make sure they check funding agreements to make sure there are no restrictions on paying board members. If they fundraise, they will also need to check that there are no restrictions in the state or territory-based laws that govern them. So, for example, in New South Wales, if an organisation is a charitable organisation subject to the Fundraising Act, the organisation must obtain ministerial approval before making a payment to a board member. And as discussed already at length, they should check that it doesn't change the nature of the legal relationship between the board member and the organisation. That is, they should make sure that the payment isn't comparable to wages that would attract employment status. Overall, they should make sure the payment is reasonable, in good faith, and they should consider implementing a policy on paying board members that could also cover off things like reimbursement.
Amy, you said generally the law doesn't prevent payment, but in some instances, and particularly companies limited by guarantee, there may be some variances. Is that right?
Yes, that is right.
Yeah. So that's the circumstances where the company limited by guarantee might have been allowed under the Corporations Act to not use the word limited in their name. And in that instance, they are prevented from making the payment to the board member.
Good, thank you, Nadine. Yes, excellent. So if you'd like some more information about whether or not you can reimburse your board members or enter into a contract of service with them, see our fact sheet, Payment of Board Members, available on our not-for-profit law website.
Thanks, Amy. And you'd find that under the governance tile?
Yes, you would. Another question that we get here in not-for-profit law is that some organisations have workers' compensation insurance and they're not quite sure whether or not that workers' compensation insurance covers volunteers. So to give you another factual scenario to put this question into context, I'm going to use the fictional scenario of Wanderers Youth Hiking Group. So Wanderers Youth Hiking Group is a not-for-profit incorporated association operating within the Blue Mountains region of New South Wales. It aims to mentor and improve the mental well-being of young people at risk by conducting group nature walks led by experienced hikers. These walks aim to promote a sense of belonging and community among the youth, as well as encourage a connection with nature. The organisation is worried about its volunteers injuring themselves on hikes. This is a real risk, and they're concerned about insurance coverage for these injuries. Nadine, do you have any advice about whether or not the insurance policies cover the volunteers?
Yeah, thanks, Amy. Well, in general, workers' compensation will not cover a volunteer. There's only very rare exceptions to situations where workers' compensation will cover volunteers. The other common insurance that a lot of not-for-profit organisations have is public liability. Now, that will usually cover injuries a volunteer may cause to others, but it's generally not going to cover injuries caused to a volunteer, which could leave the not-for-profit organisation in a very dire circumstances when they have a volunteer that's injured. So in these circumstances, community organisations should consider insurance that covers its volunteers and injuries to their volunteers. This is called volunteer personal accident insurance. And it's different to public liability, as I've just said, because that public liability is not generally going to cover a volunteer who has an accident. You should also check your specific insurance policies that you do have to make sure that all of your volunteers are covered and that the activities of volunteers are taking are also covered. More information about insurance and the different types of insurance can be found in Part 5 of our National Volunteer Guide. And we also have a detailed insurance guide available on the Not-for-Profit Law website. It goes into this a bit more detail.
Thanks, Nadine. Another common question we get is, we want to fire our volunteer. Would there be the potential for that volunteer to make an unfair dismissal claim? So to go back to Wanderers Youth Hiking Group, Nadine, so Daniel has been a volunteer of Wanderers Youth Hiking Group for 3 years. He has been the leader of numerous hikes and walks during his time with the association. Recently, Daniel has been unprepared for the walks. On numerous occasions, he has forgotten his compass, not packed enough water, and led the group in a completely wrong direction, delaying the group's return until after dark. Wanderers Youth Hiking Group primary concern is for the safety and well-being of the children and teenagers who participate on these walks. They're worried about the participants as well as its reputation and want to, I guess, get rid of Daniel from his role as the organisation's hike leader. Wanderers Youth Hiking Group come to Not-for-Profit Law and ask whether or not they are allowed to fire Daniel, and if there's any risk that he will make an unfair dismissal claim. What do you think, Nadine?
Well, I think hopefully people listening will have heard that we've already discussed this today. In a genuine volunteer relationship, either party can walk away at any time. So you can't actually fire a volunteer. They're not, but, you know, as you've just described, Amy, there are a number of reasons why an organisation may wish to end the relationship with a volunteer, particularly where the behaviour of that volunteer is putting other people at risk, as Daniel was doing in this instance. So as long as Daniel is a true volunteer, you know, and he's not an employee, under legislation in governing employment law in Australia, he would have no legal right to make an unfair dismissal claim. Wanderers can end the relationship if it's no longer working for them, and which in this instance, it sounds like it's not. But just because they're not subject to unfair dismissal laws set out in employment law, it doesn't mean that they shouldn't end the relationship in a fair and transparent way. We would generally recommend to Wanderers Youth Hiking Group and other groups in similar situations that any organisations review inappropriate behaviour of their volunteers or other workers as early as possible. A quick conversation or a meeting to remind the person of policies and appropriate behaviour can help a volunteer get back on track, and it can keep the process fair and transparent, especially if the organisation in the end decides that ending the relationship is the best way forward. However, to be comfortable and clear of the relationship, wanderers should be certain that the volunteer doesn't have any other status. If they are confident that he's a true volunteer, wanderers can end the volunteer arrangement. But it is a good idea for them to treat the ending with respect. And they should also confirm the relationship in writing. Largely for liability reasons, it is important to have evidence that the person is no longer a volunteer and that the person has been informed of that, but they are just a member of the public.
That's really great. Thanks so much, Nadine.
You're welcome, Amy.
So on the screen here, we have some additional resources. As we've mentioned throughout this webinar, Not-for-Profit Law has developed a new national volunteer guide which sets out in detail the key legal issues affecting volunteer involving organisations. The guide is in 6 parts and includes a number of templates and sample policy documents which should be read together. See Not-for-Profit Law's page on volunteering at www.nfplaw.org.au/volunteers. And on the screen there, you can see some of these parts. The key legal issues for volunteer involving organisations. Part 2, volunteer, employee or independent contractor.
And Amy, a lot of what we're talked about today will be in that chapter.
Yes, exactly. Part 3, volunteer safety.
Again, which we've already talked about today.
Part 4, volunteers and unlawful workplace behaviour. Part 5, recruiting, inducting and managing volunteers. And
that's where you'll find the volunteer agreement, the induction checklist and a sample volunteer description position.
And Part 6, organisational issues and volunteers. So along with this webinar, Not-for-Profit Law has also developed a number of other free webinars for volunteer involving organisations. These can be accessed on the same page as that you've accessed this webinar. So these 2 ones are youth volunteers, the key legal issues to be aware of, and unpaid workers, court-ordered volunteering, mutual obligation activities, and other forms of unpaid work.
Thanks, Amy, and thanks for taking the time to listen to us today. Finally, we would like to thank the Australian Government, the Department of Social Services, for financially contributing towards the development of this webinar today. Thank you.